Hey guys, it's Mr. Antoon here. Today we're going to be talking about defendant rights. So Monday and Tuesday for whatever class period you have at this point. Okay. So these are two cartoons. You can pause the video at any time as we talk today. So just go to the main idea of either one. Again, it's the Fourth Amendment, obviously, because it says it on there, but you're kind of getting the main idea from this. So the due process of the Fourth through Eighth Amendment are known as defendants' rights. This is where if you're a criminal in the future, you have these to protect you from the federal government. They have to follow this procedure, these amendments to a T, or can invalidate a conviction for you. And courts will continually rule on what is constitutional and what's not. I'm going to play this video here. It's no sound to it. They're arresting this guy in Ohio, and the perpetrator's here, and he's handcuffed, and they're now going to take out what's in his pockets to look for evidence. And watch as they drop the wallet in front of him. He sees that there's a piece of paper there, and he's now eating it. And they do not notice this because his head's down, and they're looking for other stuff. They're starting to notice and watch him smirk because he knows he got away with it. There it is. And they're confused. They're all looking around like, where is it? Because we know the evidence is on him for whatever reason. This has to be used as a training video for future officers to make sure you do not put the evidence right in front of him. So again, kind of funny start for today. In terms of the due process crime funnel, we've seen this before. Of 1,000 crimes, as we go down this funnel, everything gets smaller. Less and less happens. So of 1,000 crimes, only about 2% of people, including juveniles and adults, go to prison because we're overburdened in our prison system anyways. So a lot of them get plea bargaining. We'll talk about that one a little later. In terms of the incarceration rate from 1960 to 2012, it's risen as a result of the war on drugs, the Sentencing Reform Act, the Anti-Drug Abuse Act, and especially the three-strike legislation. This is where if you get 3 felonies, you go to prison for life. So it's it's trying to stop the crime from happening, but it's increasing the size of people in our prison system. All right, here are the 5 amendments you need to know for defendant rights and due process. It starts when they come to your door for unreasonable search and seizure and warrants. We're going to go through each one of these. So I'm just going to show you them here. We're not going to talk about double jeopardy, which is you can't be tried for the same crime twice. Like OJ cannot be tried again unless they find new evidence, and they won't at this point. We'll talk about self-incrimination. Grand jury and eminent domain is simply the United States government really owns all property, even though you guys and your mom or dad might own their property. If they want to build a freeway through your system, the federal and state governments have to give you market value for your home as they destroy it and build what they want to. That's called eminent domain. The Sixth Amendment is the right to counsel, right to trial, speedy and public, meaning it can't be behind closed doors. You're informed of these charges and you can gather witnesses during that. The seventh is I'm only going to cover it here. It's the right to a civil trial when the great amount is greater than $20. And then the Eighth Amendment is the end process where the judge can't have any excessive bail or fines as the trial is going forward. And then the ending, the sentencing cannot be cruel and unusual. And we'll finish with that one today. The first one is the Fourth Amendment. And they need probable cause. That's evidence, reason to believe with evidence that a person should be arrested. And a thing called unreasonable search and seizure is what you're protected from. They cannot, if they come into your house looking for drugs and you have a rocket launcher on your couch, they can't bust you for the rocket launcher, even though you're considered a threat with that weapon right there. So again, it has to be obtained constitutionally based on this amendment. The exclusionary rules, if it's not introduced, evidence cannot be put in the trial unless it's obtained constitutionally with the correct warrant. So it's protecting you from that. And that's from Mapp versus Ohio. Now at school, it's a little different. For me, it's probable cause if they come to my house and knock on my door and show me a warrant. For you at school, your rights, you have less rights. So if the administrator or teacher has reasonable suspicion that you smell like drugs or they feel you're doing something wrong, they can call you in. You still have the right to your lawyer or your parents to be with you. But administrators only need reasonable suspicion, which is lowering the bar for if they need evidence or not for what's happening with you at school. Here's a warrant just a warrant I found online. It shows you that this is the guy, this is the date, and they're looking for any television receiver found on the premises. So make sure as they hand this to you, you read your warrant, you get a copy of it. But anything they take, you might lose forever, and you can't sue back for that because they had probable cause to search for that stuff. So just please make sure you follow this as they look for stuff around your house. This is the OJ trial. They threw out the DNA evidence because they said it was gathered haphazardly, but they had all this evidence that on the glove there was his blood, her blood, and Ron Goldman's blood. So that therefore those were the murder gloves, and that's why they didn't fit OJ, and therefore he wasn't the murderer. So again, just some side notes because we've been talking about OJ. Here's some exceptions to warrants. They don't need a warrant if they can see it. If they pull you over like motor vehicle, they don't need a warrant to ask you to come out of the car and frisk you because you've already broken something. So if they see marijuana, a pound of marijuana in the back seat, or drugs, cocaine, you can be arrested. If you're being arrested, like the video I showed you earlier, you lose. You don't need a warrant for that. If they impound that car, they don't need a warrant to look through the car for drugs. There's a drug sniffing dog. At the border or airport, they can frisk you. They don't need a warrant. If it's in hot pursuit, here's OJ. It's more of making fun of it. It's not really hot pursuit because they did not pull him over or put spike strips in front of his car. This is when they were going to arrest him, and that's not OJ. That's his friend. OJ's in the back seat laying down with a gun to his head on the phone with the police. Exigent circumstances. If it's, here's a video of a police chase. So guy's filming it outside his house, but he was watching on TV, as you can see here. He's watching it on TV, and then all of a sudden they turn. I don't think it's a real video, but I think it's funny. They turn here, and there it is as they're going around his house. So I thought that was semi-funny, but I don't think it's real. Exigent means pressing. If the house is on fire and they find drugs, they don't need a warrant for that stuff because it's pressing circumstances. Same with an arrest on the side of a street, like these guys with all the police with their weapons out. And then stop and frisk is one of the big ones, and this is a kind of a racial profiling because it really targets Latino and Black people, and it's considered a violation of the Constitution, but it's not yet ruled unconstitutional by the court system. So keep that in mind if you hear that in the future. The strip search example, there's a video. Now you're going to have to watch the Google slide video that I'll include with this. You'll have this whole video. If you want to watch it, I'm not going to have that for time. But a girl in middle school was strip searched because a friend of hers ratted on her or tattletaled on her that she had the drugs when she was the drug dealer. So this girl, Savannah Redding, she sued the school district and went all the way to the Supreme Court. And here are the two questions the Supreme Court justice had to answer. Does the Fourth Amendment prohibit schools from strip searching students suspected of possessing drugs in violation of the school policy? Are school officials individually liable for damages in a lawsuit filed under this code from 1983? So pause the video, figure it out, and here are the answers. So the first one is sometimes. It's not yes or no. It depends on the facts of the case. But the second one is alarming. Both were 8-1, and you can see who voted, how they voted. But the second one is no, they're not. Like an administrator, if he strip searches you, he's not individually liable. It's the school district that's liable for that. So she sued the school district of Stafford, and she won $250,000. Okay? The Fifth Amendment. This is self-incrimination. I plead the Fifth, meaning you do not have to compel yourself to be a witness against yourself. Usually look guilty, and you'll see a video from Dave Chappelle a little later on. And then the Miranda warning is they have to inform you of why you're being arrested, and then your rights as well. That's from Miranda v. Arizona from '66, and this stops unfair police interrogation where they try to coerce you to make yourself guilty. This is a tough one, okay? And you can see here, this is the political cartoon where the kid broke the vase from this chair. He pleads the Fifth. Can you do that with your parents? And I think it's kind of funny because there's no way. If my kid said I plead the Fifth, they're still going to get punished. Okay, kind of funny. So do you know the Miranda warning? Most of you kind of know it. It starts out with, and then again, you can pause the video and try to figure it out on your own if you want. But there are 5 statements. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney and to have that attorney present while you're being questioned. If you cannot afford an attorney, one will be appointed for you. You can decide at any time to exercise these rights and not answer any questions or make any statements. And then they have to give you the waiver. Do you understand your rights? If you speak a different language, they have to bring in an interpreter to translate for you. So they will not take you away until they have the, let's say you're being arrested at your car or your home. They got to bring an interpreter to talk to you about this, okay? And here's some examples of the Miranda decision. Again, if you're watching this, you can pause the video and you figure out it's yes or no. So let me just read the first one, and there's a few others you can do on your own. A suspect appears in court. Police say he confessed to a number of burglaries. He was informed of his rights after his confession. Will you accept his confession? I'll give you a second. You can pause the video and figure it out. This one is no, because he was informed after he was arrested of his rights. That cannot happen. All right, so here are the other ones. I'll give you some time to pause the video if you need to. Again, pause the video if you want to read it. Pause. Pause. All right, so with the Miranda rights, I'll play this from the other guys, a movie with Will Ferrell and Mark Wahlberg. Here's when they're arresting one of the perpetrators.
You have the right to remain silent. Anything you do or say can be used, what's the next word? As a flotation device. You do or say can.
Sorry. And that's just showing you that you have to say it right or they're going to throw it out. Here's 21 Jump Street, kind of along the same path. I'll play this whole video.
The department was forced to drop the charges because you forgot to read him his Miranda rights. What possible reason is there for not doing the only thing you have to do when arresting someone?
I did read him his right. I did a version of that.
Do you even know the Miranda rights?
Yes.
Let's hear them then.
You got a lot of stuff to do.
Go ahead. You going anywhere, Schmidt? You got time?
I had a thing, but I can probably push it back.
Go ahead. It's 4 declamatory sentences followed by a question for a total of 57 words.
Okay. It obviously starts with you have the right to remain silent. I know you heard this before, and then I think it sounds something like right. You have the right to remain an attorney.
Did you say that you have the right to be an attorney?
You do have the right to be an attorney if you want to.
All right, so I'm not going to play the whole thing, but again, you get the idea of that, guys. So they have to declare the Miranda rights for you as you're being arrested. Here's Dave Chappelle's show, pleading the fifth. Remember, anyone who really does it looks guilty. Doesn't mean they are. When you plead the fifth, here it is. Oops.
I plead the fifth. I said there are so many amendments in the Constitution of the United States of America. I can only choose one. I can only choose one. I plead the fifth. I plead the fifth. 1, 2, 3, 4, fifth. Anything you say, fifth. Go ahead and ask me a question. You fifth. A secret document that I think you need to say.
So there you have it. I mean, making fun of it. Dave Chappelle's show that ran for those 4 years. All right, the Sixth Amendment is the right to counsel. Based on Gideon versus Wainwright Supreme Court case, states must provide a lawyer in most cases. Doesn't mean all cases. Mainly a felony or higher, but it can be misdemeanors if possible if you need that. The right to trial, most trial, you have a right to that trial, impartial jury that consists of 12 people. But plea bargaining is about 90% of it, where you plead guilty to a lesser crime. So you don't have as much time or as much fine that comes on. And this guarantees a speedy and public trial, so you're not languishing in prison for a year. It's supposed to happen faster. That's why they do a lot of plea bargaining, because they don't have time to have all those trials. The seventh is the civil trials, more than $20. And then the eighth is excessive bail should not be required, or fines cannot happen. And then cruel and unusual punishment. They've deemed, based on Gregg versus Georgia, the Supreme Court, that death penalty is not cruel and unusual punishment. And again, it's based on each state. So you can see here, 2 states on this list. Washington just got rid of it, I think it was a year ago. And then Colorado also got rid of it just 2 weeks ago, guys. So again, it varies by state. Here's the rise of the death penalty and all the executions that happened. You can see in 1999, they had the most, and then now we've tailed off. There's not as many that's going on here. The race of defendants executed since 1976, whites have been the most, but you can see blacks and Latinos. I mean, at least blacks have had a lot, and they don't have as many as people. It's like 10%, 12% of America, and that's a high number. And you can see the race of the victims that were killed in these situations. It was 3/4 of them were white. So again, just some background facts to some of the executions that have happened. Here are the executions. I know this didn't start where it should have started. It'll go to 2014, but each state from 1977 to 2014, you can see Texas has had the most executions since. I'll let this play out. Crazy to see that. Look at the South. All right. And here's just a cartoon on this. Again, they do botch executions, especially with the lethal injection. Look at this. Of these 1,000 total injections, they had botched 75, which is a 7% rate. And again, you can read the story of Clayton Lockett. Very sad that they administered the drug and thought he was unconscious to kill him. But once they gave the 2 drugs that kill him, he started to writhe on the gurney and clench in pain. They stopped the execution, got rid of the witnesses, and then he died 43 minutes after that started. So this is considered cruel and unusual punishment. And his family can sue, and they did. They sued, and they lost the lawsuit against the Department of Corrections in Oklahoma. And then they appealed to the Supreme Court, and the Supreme Court won't reinstate this lawsuit. They said no to it. So his family lost out, even though it was a cruel and unusual punishment. Lastly, there's a famous Westlake High School alum from 2002. His name is Ross Albright. He was the Silk Road guy who started it on the dark web. He was nicknamed Dread Pirate Roberts from the Princess Bride movie. And you could see him, but he is now incarcerated in Tucson. He was sentenced to double life plus 40 years without the possibility of parole. And he appealed to the Court of Appeals, lost, and the Supreme Court lost, and he's now serving his double life sentence plus 40 years in Tucson, Arizona. That is it for today, guys. I will see you the next one, the right to privacy. Thanks, and I'll talk to you later.